Who goes to court during the lawsuit process? Most clients who come into our office, whether it's for an injury action or an employment case, are worried about going into court. Not uncommon. Most of their perspective about what a courtroom looks like and what a lawsuit looks like comes from television or the movies, because most of our clients have not been involved in this process before. So one of the things they wonder is, do I have to go to court? And if so, what is that going to look like? Good news is, for the most part, litigants or the parties to a lawsuit don't actually have to go to court, except for very specific parts of the case. The primary one is trial, and that's all the way at the end of the case if the case does not get resolved in some other way. Now, there are depositions and other stages of the case where you will have to appear, but you're not typically doing these in a courtroom. For the most part, the court interactions during the course of a lawsuit involve the lawyers and a judge, and it's mostly procedural stuff, figuring out schedules, figuring out timelines, arguing about legal technical issues, but it does not typically involve client presence. And that's a good thing, because it removes some of the pressure from you involved in the lawsuit, thinking that you have to go to court and fearing about the fact, people ask me all the time, is the judge going to ask me questions? Bottom line is, up until the point of trial, it is very unlikely that you will have to really be in a courtroom, or that anybody other than your attorney or maybe the other attorney in a deposition will be asking you questions. If you have any questions about this, feel free to reach out to us.